Title 15 U.S. Standard Codes, Chapter 55, Petroleum Marketing Practices from Title 15 Commerce and Trade. Subchapter 1, Franchise Protection, Definition of Franchise Relationship, Trial, Interim Franchise Notification, Termination, Non-Renewal Franchise Relationship, Enforcement Provisions, Relationship, Statutory Provisions, States Law, Local Laws, Prohibition, Restriction, Installation of Renewal Fuel Pumps. Subchapter 2, Octane Disclosure, the definitions, automotive fuel rating, testing, disclosure requirement, administrative enforcement provision, relations, statutory provision, state, local laws. Subchapter 3, subsidizing motor fuel marketing, studied by Secretary of Energy, which subchapter 3 sounds the most promising. Subchapter 1, Franchise Protecting, definition. You have disturbed the term of the franchise made by the contractor, refiner, distributor, refiner, the retailer, between a distributor and another distributor, between the distributor, retailer, under refiner, distributor, as the case may be, with the authorities authorized of the permit to the related to the distributor in the connection, sale of the consignment with the distribution motor fuel trademark owned with the control of such a refiner or by refiner which supplies motor fuel to the distributor which authorizes permits such as the term franchise include any contractor with a retailer distributor as the case may be authorized permitted to occupy leased marketing premises to be employed with the connect with the sale of the consignment of the distribution motor fuel under the trademark which is owned or controlled by such a refiner by a refiner, supplier of motor fuel, the distributor which authorized permits such as occupancy fuel under the trademark owned, controlled by such refiner, supplies motor fuel, distributor authorized permits such occupancy, any contract pertaining to supply motor fuel which is to be sold or consigned to distributed under trademark owned, controlled by a refinery under contract or existing consistently in May 15, 1973 pursuant to which May 15, 1973 motor was sold, consigned, distributed through the trademark, only controlled by such a date by a refiner, and 3. Unexpired portion of franchise determined over the preceding provisions, paragraph which transferred assignment of the authorized provision, such franchise, applicable provisions, state laws permit such transfer assignment without regard provision of franchise. Term franchise relationship means in respect of the motor fuel marketing distributing obligation for publicly franchised franchise with result of the marketing fuel under franchise. Term franchisor means a refiner distributor as the case may be authorized permit under franchise retailer distributor trademark connection sales consignment the distribution of motor fuel. Franchisee means a retainer distributor as the case may be authorized permitted under the franchise trademark and connection sale consignment of the distributor motor fuel. The refiner means any person engaged with refining crude oil and producing motor fuel includes affiliated such person. Term distributor means any person including any affiliate of such person who purchased motor fuel consignment of distributing another received motor fuels consignment. Distribution motor fuels account to his supplier was not included with the employee mirror serves as a common carrier providing transport service for such supplier. Term retailer means a person who purchases motor fuel sales of the general public ultimate consumption. Term marketing premises means a franchise premises under such franchise are to be employed franchise connection sale consignment of distribution motor fuel. The lease marketing premises means the marketing premises owned leased in a way controlled with a franchise authorized permitted under franchise to employ with connection with the sale of the consignment of distribution motor fuel. Term contract means an oral written agreement for supply delivered level during several months of the previous year, such as the premium of evidence of the agreement to deliver such levels. Trademark means a trademark, trade name, service manual, mark, identifying symbol or name. Motor fuel means gasoline, diesel fuel type, distributed used fuel in self-propelled vehicles during primary use of public street, road, and highways. Term failure does not include any failure with only technical unimportant franchise relationship. Any failure caused provide reasonable control of the franchise. Any failure based on provision of franchise is illegal, unenforceable under laws of any state subdivision thereof. Terms fail to renew or non-renewal means the respect of the franchise relationship failure to reinstate, continue, extend franchise relationship conclusion on the term and on an expiration date stated relevant franchise any time in the case relevant franchise, but it does not state with the term of duration expiration date following term on and after June 19, 1978 relevant franchise entered in prior to 1978 has not been renewed after such date. The term affiliate means any person or then means the franchise controls controlled under many common control of any other person. Term relevant geographic market area includes state, standard, metropolitan, statistical areas periodically established with office management and budget. Term termination includes cancellation. Term commerce means any trade, traffic, transportation, exchange, other commerce between any state and any place outside of the state which affects the trade of the transfer, exchange, commerce described in some paragraph A. Term state means the state of the United States, District of Columbia, Commonwealth of Puerto Rico, Virgin Islands, American Samoa, Guam, Commonwealth territory possession of the United States. Alright, 2802 franchise relation general prohibition against termination non-renewal except provided in subsection B with the section 2803 title of the franchise that does not engage with the sale, consignment, the distribution, motor fuel, with the commerce. 1. Terminated franchise into the renewed on or June 19, 1978 prior to conclusion of the term expiration date stated with the franchise failed to renew of the franchise relationship without regard to date with the relevant franchise was entered or renewed. Precondition and grounds termination non-renewal. Franchise may terminate any franchise that entered the renewed after June 9, 1978 or may fail to renew franchise relationship if the notification requirements section 2804 of the title are met. Such termination is based on the ground described in paragraph 2 with the non-renewal based on the ground described in paragraph 2 or 3. For the purpose of section, the following grounds of termination: franchise non-renewal, franchise relation failure, franchise comply with the provision, franchise provision, both reasonable, material significant, franchise relation, franchise first acquired actual constructive knowledge of such failure not more than 120 days after the notification, termination, non-renewal notification given pursuant to 2804 of this title. So more than 60 days prior to the notification, termination, non-renewal, less than 90 days notification given in 2804B1 of this title. Any failure to franchise exert good faith efforts for the cut out with the provision of franchise expressed within franchise in writing, and such failure with a reasonable opportunity to good faith efforts as such carry out such provisions. Such failure they are contained with the period beginning 180 days before the notification, termination, non-renewal was given in 2804 of this title. The occurrence of the event with the relevant franchise relationship or result of the termination franchise with the renewal of the franchise relationship if it occurred with the period of franchise and effect of the franchise acquired with the actual constructive knowledge such occurrence. No longer than 120 days prior to the day of the notification, termination, non-renewal is given the notification pursuant to the 2804 of this title. No more than 60 days prior to the notification of the termination, non-renewal given in the 90 days for notification pursuant to 2804B1 of this title. An agreement in writing such as between the franchise terminate, franchise renew, franchise relationship. Such agreement entered within 100 days prior to the termination, case the non-renewal more than 180 days prior to conclusion of the expiration date stated in the franchise promptly completed such agreement in the supplementary statement described in 2804B. Within 7 days after the franchise copy of such agreement, franchise is not posted in certified mail written notice franchise reduplicating such agreement. In the case of the franchise entered for the June 19, 1970, in any case of the franchise entered for the renewed lesson in the term 3 years or longer, respect with the franchise offered for the 3 years or longer, termination made with the franchise good new for the normal course of business, withdrawal marketing food for the retail outlets relevant geographic market area and the marketing premises located. Such determination was made after the date of such franchises were entered and renewed, which based on the occurrence and change of the relevant facts, and circumstances of such date. In the termination renewal, non-purpose of converting premises of the subject franchise of the operation employee agent franchise such a franchise owns account of the franchise during a 180-day period notification pursuant to 2804. Either made a bona fide offer to sell, transfer, assign with the transfer of the franchisees to the franchisor interest such premises if applicable the offered franchise right of the first refusal at least 45 days duration and made another purchase of such franchise interest such premises. In the case sale, transfer, assignment, and another person franchise interest premise connection with sale, transfer, equipment, and other person franchise interest one or more of the marketing persons offer the good faith franchise term condition discriminatory franchise compared franchise currently being offered such other person franchise effect respect to such other person as a franchisor. For this subsection, the following grounds for the non-renewal franchise relation failure, franchise agreed change of the addition provision with a franchise, such change of the addition with the result of the termination franchise with good faith with the normal course of business. Such franchise will not result of the franchisor's insistence upon change of the addition with the purpose of converting leading marketing base for the employee with the agent transaction for benefit of the franchise with the otherwise preventing renewal of the franchise relationship. Receive the numerous bona fide customers complain with the franchise control of the franchise operation marketing if the transfer of the previous experiment existing in the nature of search of the complaint received such complaints of the franchise if the complaints conditions such premise of the employee of the franchise did not take action and to cure or correct the business such complaints failure to franchise of the operating marketing improve clean safe health meaningful and fail to do so will prevent in case and franchise notify franchise such failure. If in this case, franchise entered in July 1978 and expired term of such 3 years or longer. In case franchise entered renewed such date with a term which was 3 years or longer, restrict with the franchise offer 3 years or longer. Determination made with the franchisor in good faith and normal course of business. If such determination converted lease marketing premises, other use the sale of the Russian motor fuel materially added to replace such premises, such of the and sell such premises renewal franchise relationship with the uneconomical franchisor, despite reasonable change, reasonable addition provisions, franchise may accept the franchisee with their determination subclass 2 and 4 of the determination made pursuant to the lease marketing premises operation, operating employees, agents, franchisor, or the franchisor's own account, own lease marketing such franchise during the day before notification pursuant to 2804, either made a bona fide offer to sale, transfer of the transfers, franchisor's interest, such premises, and if applicable, the offer to transfer a right of refusal within 45 days after an offer made by another to purchase the franchisor's interest of such premises. Or a definition using section B2 within the event of the relevant franchise result of the termination franchise with a non-renewal franchise relationship reasonable that includes events of the criminal misdemeanor franchisee relevant to operating marketing purpose of the declaration of bankruptcy, judicial determination involved within franchise and continuing to serve physical, mental disability of the franchise at least 3 months, the duration rendered for the franchise owner provided of the condition proper operation market premises, loss of franchisor's right to grant permission, lease market premises expiration, underlying lease if the appropriate franchisee was noticed prior to the commencement of the term of the existing franchise of the duration under the leasing. Of the fact that under leasing might expire with a not renewed term during the search franchise case of the termination in such term and the costs of the new non-renewal. During 90-day period after notification given in pursuant of 2804, franchisors offer to assign the franchise an option to extend the underlying lease option, purchase, marketing permits with the help of the franchise. If they accept the franchise conditional assignment upon the release franchise of an additional release executed by the landowner franchisee, the releasing of the franchisor of any liability accruing after the date of assignment of the M1 financial obligations under the option resulting in extended lease purchase agreement, environmental contamination, organization from the marketing premise of the operation condition of the marketing premise, instrumentation executed both landowner and franchisee, of the franchisor, contract franchisor, reasonable accept the marketing price for the purpose of the testing, remediating, and environmental contamination may be present at the premises. Situation with the franchisee acquire the possession of lease market premises immediately after the loss of the right of the franchise of the grant possession through the assignment of possession. Subparagraph B with the by obtaining the new lease purchasing marketing premises land over the franchisee is requested in writing. The franchisee no later than 30 days after the notification was pursuant in 2804 during the 90-day period of the notification pursuant to 2804 of the settle. Made a bona fide sale of the transfer of the assignment of the franchise, interest of the franchisor, improvements to equipment located on the premises, applicable to the officer of the right of the lease, first refusal and 45 days off the made by another person interest of the franchise of the improvements in equipment, condemnation of any taking whole and part with the marketing pursuant and premises pursuant to the power of an eminent domain, loss of the franchise's right to trademark subject to the franchise, unless such loss of the due mark trademark abuse violation, state law, other fault in the negligence franchisor, substance abuse violation of the negligence related action, bad faith franchisor, restriction other than the franchisor, all substantial part of the marketing premises, failure to franchisor to pay franchisor, time, manner, and also of the franchisor legally entitled, failure to franchisor to operate marketing premises for 7 consecutive days, such less period under fact circumstance constitute unreasonable period of time, willful adoration, misbrand motor fuels, trademark violation by franchisee, knowing failure of franchisee to comply with federal, state, local regulations relevant to operating marketing premises, conviction of franchisee, felony import involving moral turpitude. Compensation, etc. franchise upon condemnation, destruction, marketing premises. In any case of the termination, franchisee entered and renewed after June 1978 with a case of non-renewal franchise relation with regard to do the franchise relationship was entered into renewed. Such termination, non-renewal based event described in C5 franchisor fairly apportioned between franchisee compensation received of the franchisor based on any of the loss of the business opportunity, goodwill. Such transportation, non-renewal based event described as E7 lease market premises subsequent rebuilt, replaced franchisor operated under franchisor a reasonable period of time, grant the franchisee right to refusal of the franchise under such premises are to be operated. 2803, trial and interim franchise with non-applicable statutory non-renewal provisions. Provisions section 2802 of the title shall apply with the non-renewal any franchise relation under for trial of the franchise or an interim franchise purpose. The section term trial franchise means a franchise which entered the on after June 19, 1978. Franchise was only observed as a part of the franchisee of the franchisor of the initial term of the period not more than 1 year, with the writing and sales clearly conspicuous of the franchise of the trial franchise during the initial term of the franchise of the franchisor may fail to renew the franchise relationship. Conclusion: the interim stated with the franchise notification franchise via according provision 2804 of the franchise of the intent with not to renew franchise relationship with the provision section 2802 limiting the right of the franchise to renew the franchisee relationship with the applicable to such franchise. The term trial franchise does not include the unexpired period of any terms of franchise of the other trial franchise of the defined in paragraph 1. Transfer to some of the franchise extent of the authorized of the provision franchise applicable provision state law with the premise transfer assignment without regard to any of the provision franchise of the interim franchise made with the franchise of the entered on in June 19, 1978 with the term which combined with the terms of the prior interim franchise the franchise does not exceed 3 years effective date immediately after expiration prior franchise applicable marketing price premises which not renewed in such renewal was based on termination described in section 2802B2E of the title of the requirement of section 2802B2E satisfied with the writing and sales states clearly conspicuous of the franchise interim franchise the duration of franchise of the franchise there may fail to renew the franchise conclusion term stay with the franchise made for the determination made by the franchisor good faith normal course of business with withdrawal from the marketing of the motor fuel through the retail outlets relevant in geographic marketing area of the marketing premises located the requirements of section 2802B2E 2 and 3 with its sales satisfied. Non-renewal upon statutory notification. The notification requirements of 2804 of the title met with the franchisor may fail to renew any of the franchise relation under franchise with a continuously in term of the such trial franchise under initial term of franchise. Inclusion of the term such term franchise such for non-renewal based determination described in section 2802B2E of the title of the requirement section 2802B2E 2 and 3 of the title are satisfied. 2804 notification and termination of the non-renewal franchise relationship general requirements applicable franchisor prior to termination franchise non-renewal franchise relation franchise furnish notification such termination such non-renewal franchise whose part of such franchise relationship with the man with the described in subsection C expect with the provided in subsection B within not less than 90 days of the termination non-renewal takes effect. Additional requirements applicable to the franchise of the in circumstances would not be reasonable the franchise furnished notification not less than 90 days prior to the date of the termination non-renewal takes effect as required in subsection A2. In this case, for the least marketing premises, such franchisor may be established a new franchise relation with respect to such premises before expiration 30 days, which began on the day of the notification posted and personally delivered. If in a later day of the termination non-renewal takes effect, it may be permitted with a franchise agreement repose such premises in circumstances under which reasonable to do so operative of the premise employees of the agent. In this case, the termination franchise non-renewal franchise relation pursuant to the provision 2802B2E title section 2803 2 of this title franchisor shall furnish notification franchise not less than 100 days of the termination noted non-renewal takes effect. Promptly provide a copy of such notification together with the plan describing the schedule of the conditions under with the franchise of the withdrawal of the marketing motor fuel retails out relevant geographical area to the governor each of the state with the ports in such area. Manner and form of notification under this section shall be in writing, shall be posted certified mail personally delivered, and franchise shall contain a statement intention to terminate franchise does not renew franchise relationship together with the reason thereof on the day of such termination unreasonable take effect with a summary statement prepared under subsection D. Preparation, publication, statutory summary is no less than 30 days after June 19, 1978. Secretary Agency shall prepare a publish Federal Register simple and concise summary of the provisions subchapter, including statement of the respective responsibility, remedies, and relief available to the franchisor and franchisee under this subchapter. In this case, the summary is required to furnish under provision 2802B2D of the Title C3C section before the date of publication. Summary Federal Registry. Such summary may be furnished not less than 5 days after the published rather than the time required under such provisions. 2805 Enforcement Provisions. Maintenance of the civil action transfer against franchisees of jurisdiction, revenue, time commencement action. Franchisor fails to comply with the requirements of 2802, 2803, 2807. The franchisor maintain a civil action against the franchisor. Such action may be brought without regard conversely and with the District Court of the United States within the judicial district of the principal place of business such franchisor located with such franchisee or is doing business except no such action is maintained and commenced within 1 year after the date of the termination franchise non-renewal franchise relationship. Due to the franchisor fails to comply with the requirements of section 2802, 2803, 2807 of this title. Equatable relief of the court on the bound requirement of ground non-exercise court equatable powers. In addition, any action under subsection A of the court shall grant equatable relief to the court with the determined necessary with the remedy effect of any failure to comply with the requirements 2802, 2803, and 2807 of the title, including declaratory judgment, mandatory prohibitive injunction relief, and terminable equatable relief, except for the provided in paragraph 3. Action under subsection A of the court shall grant a preliminary injunction if the franchises which he is a party shall have been terminated franchise relation for which he is a party not renewed. There exists sufficient serious question goes into the merits. Such questions are fair grounds for litigation. The court determines that a balance of hardship imposed on the franchisor over the issuance of preliminary injunctive relief will lessen the hardship that would be imposed if the franchise preliminary injunctive relief were not granted. Nothing in subsection prevents any of the court requiring franchisee any action under subsection A of the post upon with the amount established by the court prior to the issuance continue with the equatable relief. Any action under subsection A of the court now exercise equatable power compel continuation of the renewal of the franchise relationship if such action was commenced no more than 100 days after the date of the notification pursuant to 2804B2 of the title posted personally delivered to the franchise no more than 30 days after the date of the termination such franchise non-renewal such franchise relationship takes in effect within 90 days notification was provided pursuant to section 2804B1 of this title. Burden of proof and burden of going forward with evidence and action under subsection A. Franchisor shall have burden proof of the terminating the franchise of the non-renewal franchise relationship. Franchisor shall bear burden going forward evidence to establish an effective affirmative defense such for the termination and renewal of the permitted under section 2802, 2803 of the title. If applicable, such franchisor compelled with the requirements of 2802D of this title. Actually exemplary damages attorney expert witnesses frees the franchisee determine the court right to exemplary damages amount attorney expert witnesses franchisor to frivolous actions. If the franchisee prevail any of their subsection A franchise entitled to consider the federal rules of civil procedure, actual damage in case such action with the conduct franchisor will disregard requirements section 2802, 2803, 28 of the title, where the franchisee they are under to explanatory damages where appropriate. Reasonable to terminate expert fees, witness, franchisor until the court determines the nominal damages award for such franchise in court its discretion not to direct that such fees paid to the franchisor. In the question of award with the explanatory damage amount, any such award determined by the court, not a jury. Any action subsection A of the court may disagree with the direct reasonable attorney expert witness fees paid by the franchisee and court finds such action frivolous. Discretion power from court to compel the continuing renewal franchise relationship grounds of non-compulsion right franchise with the actual damage attorney expertise witness fees unaffected. If any action under subsection A respect to the failure of franchisee renew franchise relationship compliance requirements section 2802 title of the court may compel the continuing renewal of the franchise relationship. Franchisor demonstrates satisfaction with the court that A, the basis of the non-renewal determination made franchise with good faith of the normal course of business, for at least marketing premises, even the other sales of distribution motor fuel, materially alter, add, or replace such premises, sell such premises with withdraw marketing motor fuel with the retail outlets relevant to geographic market area the marketing promise is located. The renewal franchise relationship likely uneconomical franchisor despite reasonable change, reasonable addition, provision franchise with acceptable to franchisee requirements in 2804 of the title has been complied with. The provision paragraph 1 shall not affect the right of the franchisee to recover actual damage reasonable attorney expert witness fees under subsection D non-renewal prohibited in section 2802 of this title. If release of waiver of the rights, no franchisor shall require the condition of entering into the renewing franchise relationship with the franchisee to release, waive any right of the franchise has under the subchapter of the other federal law. Any right of the franchisee may have under any valid applicable state law. No provision of the Franchise will be valid and enforceable. The provisions specify the interpretation and enforcement of the franchise shall be governed by law. Any state other than the state in which franchise has principal place of business for franchise. Alright, 2806, relation with statutory state law, local laws, termination, non-renewal franchise, extent of the provision, subchapter, apply with the termination, furnishing, notification with respect with the franchise, non-renewal, furnishing, notification with respect to any franchise, relationship state, political subdivision, they are adapted and enforced continually effect with the provision, law, regulation, including any remedy, penalty, act, ability to violation thereof with respect with the termination, with the furnishing, notification with respect thereto, any such provision, franchise, non-renewal, furnishing, notification with respect thereto, such franchise, relationship, such provision, law, regulation, same with the applicable provision in subchapter. In the state public subdivision, state may adapt and enforce continue any effective provision of law, including regulation that requires payment of the goodwill franchise, termination franchise of the non-renewal of the franchise relation authorized by this subchapter, transferring and assignment of franchise. The subchapter authorizes any transfer assignment of any franchise prohibited with the transfer assignment of the franchise with the authorized provisions such as the franchise applicable provision state law, which permits such transfer assignment without regard to any of the franchise. Nothing in this chapter shall prompt any of the states specifying the terms and conditions of any of the franchise and franchise relation may be transferred to the designated successor of the franchisee upon the death of the franchisee. Okay, 2807, the prohibition, restriction, installation of the renewable fuel pumps. Definition, renewable fuel pump. Renewable fuel means any fuel at least 85% of the volume consists of the ethanol and a mixture of the biodiesel with the renewable diesel with the defined regulations adopted the pursuant 75-45-0, Title 42, CF 40 CFR, Part 80, determined without regard to kerosene containing less than 20% biodiesel renewable diesel. Franchise-related document. Franchise-related document means the franchise number, the chapter of any other contracted directive of the franchise relating term of the condition contains no sale of the fuel by a franchise. Prohibition. In general, no franchise-related document can enter the renewed after December 19, 2007, contain the preventing all franchise, restrict the franchise, any affiliate franchise from selling a marketing permit of the franchise of the renewable fuel pump, taking existing franchise. The franchisor may restrict installation tank lease marketing premises such franchisor. Converting an existing tank at a pump with the permitting premise of the renewable fuel uses along with the tank and some such tank at a pump with a pipe connecting and are warranted, manufacturer certified for recognized standards such an organization to be suitable for such renewable fuel. Advertising included through the sign sale of the renewable fuel, setting renewable fuel specified area marketing premises franchisee include any of the name, logo, franchise, any appears purchasing renewable fuel source of the franchise if the franchise does offer renewable fuel by sale of the franchise. Listing renewable available prices, including service station signs, fuel dispenser, light poles, allowing payment of renewable with a credit card, so long as activity described in subparagraph A through G do not constitute mislabeling, misbranding, alteration, or other trademark violation of the franchise. Effective of the provision, nothing in this section can strive to preclude the franchise with require franchisee to obtain reasonable identification insurance policies. Exemption to 3-grade requirement, nothing, no franchise-related document requirement. 3 grades of gasoline to be sold with applicable franchise shall prevent franchise from selling renewable fuel in lieu of one and only 1 grade of gasoline. Alright, subchapter 2, octane disclosure.